The judge in the Kyle Rittenhouse case has just ruled that the people who were killed by Kyle Rittenhouse and the guy who was injured by Kyle Rittenhouse could not be referred to as victims. Here's the legal reason why he was right. My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. Hey, what's going on? I know this is a different type of video than I usually do, but I thought this issue was important because the media loves to spin these rulings as racially insensitive, or like there's this underlying tone of racial inequality in some of these judicial rulings that have come down in some of these more popular cases. So I want to make it clear to everybody that this judge's ruling is not only common, but it's actually appropriate for what the case is. And I'll go through some other examples of where this has actually happened before in cases that you are probably familiar with. So first, some background. See, Kyle Rittenhouse is accused of killing 2 people and injuring a 3rd man during a protest in Wisconsin. Now, if you want to know the details to that case, click this link here and it'll take you to my analysis of that case. But here's the quick and dirty. Now, Kyle Rittenhouse is claiming self-defense in his murder trial. Now, Kyle Rittenhouse is accused of killing 2 men, Joseph Rosenbaum and Anthony Huber. Now, the prosecution must prove beyond a reasonable doubt that Kyle was not acting in self-defense when he killed these 2 men and injured a 3rd. Now, in the United States, we have the presumption of innocence, where a criminal defendant is presumed innocent until proven guilty. And in this case, Kyle Rittenhouse is presumed innocent. Now, with that said, if the state is allowed to characterize these men who were killed by Kyle Rittenhouse as victims, then that would essentially attack the presumption of innocence. And the reason being is that they're only victims if Kyle committed a crime. And that determination, whether Kyle committed a crime or not, has to be determined by the jury. Now think about this. By claiming that these men are victims, the prosecutor or the state could lead the jury to infer that the defendants are guilty already, inevitably removing that presumption of innocence. Now, this would also undermine their claims of self-defense by kind of preemptively saying that they're guilty because, look, these are victims, rather than these are people killed, and determining whether they're victims or not is up to the jury based on the facts in front of them. And the jury must determine if a crime was committed before you can characterize the decedents as victims. This is something that's not unusual. Each state had its own rules on whether the state can call decedents victims or not in these type of criminal prosecutions. But there's always a level in which the prosecutor can't overstep their bounds. For instance, let's look at the George Floyd case. Now, if you watch that case or watch my coverage of the case, you'll notice that the prosecutors and even the witnesses, they refer to George Floyd as George Floyd. They rarely refer to him as victims. And the reason why is because the defense attorneys asked that George Floyd not be referred to as a victim. As the Atlanta Black Star reports, Derek Chauvin's attorney asked judge not to allow George Floyd to be called a victim or compared to Jesus. Now, in responding to that motion in limine, the court ruled this. The defendant moves the court for an order to preclude the state or any of its witnesses from referring to George Floyd as the victim or accused in this manner. And this, I think, is important so everybody understands that this is commonplace in the criminal justice system. The judge then goes on to say, the parties and witnesses may refer to Mr. Floyd as victim, alleged victim, the deceased, or any other respectful term reasonably based on the evidence, right? So even here, it's reasonably based on the evidence. But the court's preference is that the parties and witnesses refer to Mr. Floyd as Mr. Floyd or George Floyd. So even in Minnesota, they are allowing that George Floyd be referred to as victim, but only if the evidence allows it. And the court says it is the preference of the court that he only be referred to as Mr. Floyd or George Floyd. And that's what I mean by each state has different rules. In Wisconsin, they may be a little bit more strict on using such a term because they feel the prejudicial value, the prejudice to the defendant may be too high, so don't call them victims, just call them by their name. Where in a state like Minnesota, they may give a little bit more leeway, but this is not uncommon. For instance, in the Ahmaud Arbery case, which is also going on at about the same time, the defense attorneys also asked for the same thing. They asked that Ahmaud Arbery not be referred to as a victim during the trial. And here's what they wrote. According to the motion, it is such a loaded word, and it would unfairly prejudice the jury against the defendants, undermining their right to due process by impugning their presumption of innocence. This motion argues that by calling Ahmaud Arbery a victim, the prosecution would lead the jury to infer the guilt of the defendants, undermining their claims to have acted in self-defense rather with criminal intent. Now, this brings us back to the Kyle Rittenhouse case. So the judge, because of the prejudicial value of calling the decedent's victims, has ruled that you can't refer to them as victims. Now, the piece I think everybody's kind of confused about is that the judge then allowed the victims to be referred to as rioters, looters, and arsonists. But what the headlines aren't telling you, that's only if, right? Only if there is evidence that they were actually rioting, looting, and arsonists. So you can't just go and say this person's a murderer without any type of facts or evidence. That's not allowed in court. You have to have some reasonable basis and some evidence to show that based on this evidence, it's a reasonable belief that these people were rioters, arsonists, looting, what have you. Now, you may say, well, what's the difference between these witnesses versus the defendant, the presumption of innocence? See, the defendant is presumed innocent, and these witnesses aren't on trial. Now, I personally had the same issue with this in the past, with one of my cases. This was actually front page news of the New York Times earlier this year with one of my clients. Now, in that case, my client was accused of assaulting a man who had allegedly graped a woman. Now, I'm using the word grape. Hopefully you understand. Remove the G. Now, my client was charged with assaulting the grapist, but the grapist was not charged with grape. Now, in my case, I asked the state not to refer to the grapist as a victim. I also asked that I can refer to the grapist as a grapist. Well, the court allowed me to refer to the grapist as a grapist only if I had evidence that the grapist actually committed a grape. So what was the evidence that I had? Well, I had 3 victims who were willing to testify that this person was a grapist. And I had the victim who was saved by my client willing to testify that this person was a grapist. So the court was going to allow me to refer to this alleged assault victim as a grapist because I had enough evidence to show that that was likely the case. And my client's case was dismissed because, you don't want to have your star witness up there and me proving that he is a serial rapist. And that's the same thing here in the Kyle Rittenhouse case. If the defense team doesn't have any evidence to show that these men were looting or committing types of arson or doing anything that was illegal, they're not just going to be able to make those allegations in a void or in a vacuum. They're going to have to be able to show that they have evidence that any one of these victims, for lack of a better word, were looters, rioters, or arsonists. Now, I know this is difficult because whenever you talk about these cases, especially involving race, the first thing everyone sees is race. But as you guys know, and the reason why you guys love my channel is because I try so hard to stick with the facts, and sometimes race does play a role. But you have this young white guy killing 2 other white people. I think race may play some role, but as most of you already understand, if race does play a role, there has to be some facts that show us that race does play a role. And as I always say, I like to be a slave to the facts so we can make the right legal analysis, because that's what it always comes down to, the facts and not the spin. Now, I think it's really sad that the news media is spinning this as some type of racial injustice. But the fact of the matter is, this is a common practice with defense attorneys. As a defense attorney, you don't want the prosecution's witnesses to be labeled as victims. That's not good for your client. And that's why you make these motions. And that's why these motions are extremely common. So let me know in the comments section if this was informative, if you guys now understand it, and how you feel about whether labeling people who were murdered victims or not, or how it works with the presumption of innocence. I'd like to hear your thoughts. And I know this is a different type of video, but I thought this was important to understand there's a legal reality on why these things happen, and there's a political reality that's just being spun for no reason at all. Again, this is a common practice, and I think if you look at all the most popular cases that involve self-defense and murder, you'll see that this is if you don't make this motion, you're probably a bad attorney. If you like what I do and you love this type of content, don't forget, like, share, subscribe. My name is Nate the Lawyer, and I will see you next time. Peace.